Welcome to the Magna Charta newsroom this afternoon of the Akademie für die Rechtspraktik. My name's Gary Bourne, and I'm your webinar presenter today. I'm the chair of the International Arbitration Practice at Wilmer Cutler Pickering Halen Dorr LLP in London and Berlin. And my topic today is an introduction to international arbitration. It is a big topic. One could write volumes about international arbitration. People have written volumes about it. But my task today is, in the space of 50 minutes or so, to provide a summary, an overview of the basic principles and practices of international arbitration. It's intended mostly for those who don't have a lot of prior experience with learning about international arbitration, but it's also intended as a kind of refresher course for those who may spend time in the international arbitration practices of their firms or businesses or law schools. It's always good to go back to a familiar subject and, just by way of refresher, recall what its basic principles are as one thinks about specific issues. The roadmap of the topics that I'm going to cover in the next 50 minutes or so is on the current slide. You can see it there. We'll start with a definition of international arbitration, then look briefly at the objectives of international commercial arbitration. The focus of this introduction will be commercial arbitration, international commercial arbitration, as distinguished from investor-state arbitration and state-to-state arbitration. I'll touch on those two topics very briefly at the end of the introduction. You can see them at points F and G, but the focus of our discussion is going to be on international commercial arbitration. And in particular, I'm going to look at the legal framework for international commercial arbitration, look at international arbitration agreements, arbitral procedures, and arbitration awards before then, as I say, I close out with investment arbitration and state-to-state arbitration. I'd like to start with a basic definitional question. What is international arbitration? Arbitration, as we know from both domestic and other settings, is a consensual process, a process of consent by which parties agree to a particular means for resolving their disputes. Arbitration is used in numerous domestic settings. It's been widely used over the centuries in all sorts of contexts: commercial, trade associations, religious groups, institutions of other sorts. It's also been used for investment and state-to-state arbitration, both historically and presently. Specifically for today's purposes, but also a more generally applicable definition, defines arbitration as the party's consensual submission of a dispute to a non-governmental decision maker selected either by the parties or for the parties, who will finally resolve their dispute, giving the parties an opportunity to be heard in an adjudicative process. And all of the elements of that particular definition are important. Arbitration is based on consent, the consent of the parties, the agreement of the parties to arbitrate. It involves a non-governmental decision maker. That means someone other than a national court judge or a state administrative agency of some sort. It's a person, an individual or a group of individuals, arbitrators, an arbitral tribunal, selected by the parties, sometimes directly by the parties, with each party naming an arbitrator or agreeing upon a sole or presiding arbitrator, or alternatively an arbitral institution, or in rare cases a national court, selecting this person, this arbitrator or group of people, arbitrators, to resolve the party's dispute. A characteristic aspect or feature of arbitration also is, as you can see on the slide, that the arbitrators finally resolve the parties' dispute. They don't recommend a decision. They don't encourage the parties simply to consensually agree to a particular settlement. Rather, the arbitrators make an award, a final and binding award, that is enforceable in courts, national courts, just the way a national court judgment is, indeed, as we're going to see, more enforceable than most national court judgments. And then finally, arbitration is a process of adjudication. It's not a process of executive power or authority. It's not a process of legislation where the legislators simply decree what is right or what they think is good policy. It's rather a process of adjudication in which a tribunal hears certain facts and applies legal rules, law, to those facts to make a reasoned decision, an arbitral award, which will then bind the parties. Arbitration agreements typically take the form of, and this goes back to the essentially consensual nature of arbitration. Arbitration agreements typically take the form of agreements in commercial contracts or conceivably treaties, other instruments, to arbitrate future disputes. You can see an example of a typical arbitration clause of this nature, which would appear in the body of a broader contract on the slide in front of you. It provides, and I'll read this out because the language is both short but also very important. All disputes, claims, controversies, and disagreements relating to this agreement shall be finally resolved by arbitration by 3 arbitrators or alternatively 1 arbitrator. The seat of the arbitration shall be The Hague, Netherlands, Paris in France, London, England. The parties are free to choose both the number of arbitrators that they wish, as you can see, the seat of the arbitration, as you can also see, and the other aspects of the arbitral process as well, the scope of the arbitration, the language of the arbitration, and so forth. But the vast majority of all arbitrations, all international arbitrations, because although this clause could be used in a domestic contract, we're focusing on cross-border contracts, international agreements between parties from different nations, different jurisdictions. The vast majority of all international arbitrations occur pursuant to an international arbitration agreement, much like this one that you see before you. These agreements can come in all shapes and in all forms. They can be very short. Some arbitration agreements can be as short as the word arbitration, although it's by no means recommended. Some arbitration agreements can be pages long in complex transactions, although, again, that's also not necessarily recommended. Most arbitration agreements, and this is a bit more to be recommended, take the form of simple institutional arbitration clauses providing for the arbitration of future disputes, disputes that have not yet arisen under a particular contract or set of contracts. Now, although that is the general way that international arbitrations arise, it's not the only way. You can also have, and there's a reference to this in the second bullet point on the slide, you can also have so-called submission agreements or compromis, where you have a dispute that has already arisen, an existing dispute. And the parties agree to submit that dispute and only that dispute to arbitration. The parties enter into a contract. For whatever reason, their contract doesn't have an arbitration or dispute resolution provision in it. After a dispute arises, though, the parties say, wouldn't it be sensible for us to resolve this by arbitration, just this dispute? And that dispute then can be submitted to arbitration. Note the difference between that and the language of the model clause that you can see in the preceding bullet point, which refers to future disputes, all disputes which may arise in the future. It's worth taking a moment to think, as we define international arbitration, as we define arbitration, to think about what isn't arbitration. A good way to define what something is by looking at what it isn't. And what arbitration isn't is either mediation or conciliation. You can see the definitions of those two processes. A mediator or a conciliator, they're closely related processes, encourages the parties to attempt consensually to agree upon a resolution of their dispute. The mediator may recommend, may encourage, may facilitate, but what the mediator and the conciliator do not do is to resolve the parties' disputes over one party's disagreement. The mediator and the conciliator do not have the power to adjudicate, do not have the power to decide, only to facilitate, only to discuss and to encourage. And in that manner, although arbitration and mediation are alternative forms of dispute resolution, different from national courts, there's a fundamental difference between the two. Arbitration results in a final and binding award, a final and binding resolution of the parties' dispute. Now, arbitration also is not expert determination, although it may sometimes look close. You often see provisions, especially in technical parts of commercial contracts, for expert determination. For example, if there's an issue of accounting in a share purchase or acquisition agreement, if there's an issue of complicated accounting questions, or alternatively an issue of construction expertise, you may see parties refer that dispute and only that dispute to a final decision by an expert. And in some ways that's similar to arbitration in the sense that it's not a national court, it is a non-governmental decision maker chosen by the parties, but it's different from arbitration in that the expert can go off on her own, off on his own, conduct investigations without the parties being present, not follow rules of procedures that give each party an opportunity to be heard and to appear at a hearing, but instead simply conduct research using their own expertise and knowledge before rendering a final decision. In that respect, that difference between an adjudicative process of arbitration, where the parties have an opportunity to be heard, and a research investigative function of expert determination, where the parties don't necessarily have an opportunity to be heard, there is again a fundamental difference between arbitration and other forms of alternative dispute resolution. And finally, there's a difference, of course, between arbitration agreements on the one hand and forum selection or choice of law or choice of court clauses, on the other hand. A choice of court or forum selection clause provides that the parties' disputes will be resolved in a particular court and no other court. That forum selection clause has similarities to an arbitration clause in that it chooses a particular forum, a national court, but it's different in that arbitration selects not a national court, but as we saw in my definition a while ago, a non-governmental decision maker, an arbitrator. And what results from that arbitral proceeding is not a national court judgment, but instead an arbitral award. So that, in a nutshell, is international arbitration, and in particular, international commercial arbitration as a definition. Why is it that parties agree to international commercial arbitration? Why is it that that model arbitration clause that we looked at is included in commercial contracts so frequently? And we're going to look in a moment at just how frequently. There are a multitude of reasons, and you can see the more important ones summarized on this slide before you. One of the most fundamental reasons, and this applies in the international context, one of the most fundamental reasons is that of neutrality. You have parties from two countries, let's say England and Malaysia, entering into a commercial agreement. The English party doesn't want to be in Malaysian courts. Conversely, the Malaysian party doesn't want to be in English courts. Both parties may have mistrust about the specific character of one another's courts. The English party may not think Malaysian courts are particularly expert or reliable. The Malaysian party may think English courts are too expensive. But more fundamentally, both parties have deep reservations about being on one another's home turf. They're concerned that they may be the subject of some sort of explicit or unstated bias against foreigners, that their local counterparty may have connections with, relationships with, sympathies with local courts that they can't match, and that at the end of the day, in a hard-fought dispute, will be a decisive factor tipping against them. So both parties then, on the one hand, wish to have their own home courts as a place for a favorable battleground for future disputes, and yet don't want, more than anything, to be in their counterparties' home courts. Out of that opposing clash of interests comes typically agreement on both parties, not first, but second choice. And both parties' second choice is, if I can't get my own home courts as the forum for dispute resolution, I'll accept a neutral forum. And international arbitration, not seated in either party's home jurisdiction, in the territory of a third state, under the legal system of a third state, provides a neutral and objective forum for dispute resolution, which is one of the most fundamental reasons for parties to agree to international commercial arbitration. There are other very important reasons as well, though. There's the commercial expertise of the arbitral tribunal. Unlike a national court judge who hears a whole range of different disputes, landlord-tenant disputes, tax disputes, employment disputes, computer law disputes, you name it. The national court judge hears it. An arbitral tribunal can be selected for a specific case depending upon the demands of that case. If you have an insurance dispute, for example, one can pick arbitrators with insurance expertise, insurance arbitration expertise. If you have a construction dispute, you can pick arbitrators that are familiar with construction techniques. Perhaps if you have, for example, a hydroelectric dam, arbitrators with specific experience in that kind of project. Arbitrators with the relevant legal expertise. Arbitrators who, if you have a, let us say, German joint venture dispute, have experience in German law on the one hand, joint venture disputes on the other, rather than going to a national court, let us say England, where the judges don't speak German, aren't familiar with German law, and aren't necessarily expert in joint venture disputes. That commercial expertise, as compared to either generalist national court judges or lay juries that you find in some jurisdictions, is considered to be a substantial advantage of arbitration. Equally important, international arbitration agreements and arbitral awards, both the front end of the process with enforcement of agreements and the end of the process with enforcement of arbitral awards, are substantially more durable, substantially more enforceable than their counterparts, being national court judgments and choice of court clauses. We're going to look in a few moments at the New York Convention, signed in 1958, now 149 state parties to it, guarantees the enforceability, the portability of international arbitration agreements in all 149 of those jurisdictions, and the recognition of arbitral awards, the enforcement of arbitral awards made abroad in all 149 of those jurisdictions. There is no counterpart to that for forum selection clauses or national court judgments. And what that means is, when you obtain an arbitral award in your favor, or when you seek to enforce an international arbitration agreement, you can actually do that. Unlike a national court judgment, which doesn't have the benefit of a global convention, national court judgments won't necessarily be recognized under treaty obligations. International arbitral awards are very likely to enjoy that enforceability, what one might call an enforceability premium. Party autonomy and procedural flexibility. Parties are free to design the arbitral procedures in a way that they think best for their particular case. They can agree to arbitration in a fast-track procedure. They want the dispute over and done with in 3 months. They can agree to that. They want the arbitration to involve site visits to the hydroelectric dam site, for example. They can agree to that. Arbitration also can enjoy, doesn't necessarily always enjoy, but can enjoy advantages of cost and speed. If the parties want a fast-track arbitration that's cheap, they can agree to a sole arbitrator with a fast-track arbitration. If the parties don't want to have an appellate process, arbitration is based on the premise that there will be virtually no appellate review of arbitral awards. Finally, and just quickly, arbitration tends to be more confidential and more private than national court litigation. National court litigation frequently occurs in the glare of publicity, evening news out front of the courthouse in the worst case, your competitors sitting inside the courtroom, or reporters in the courtroom in a less bad case. But in either situation, you don't have the confidentiality that arbitration allows the parties to agree to, subject to some caveats, but in principle, the potential for confidential and private dispute resolution proceedings. Now, based on those various objectives, seen by many commercial parties as real advantages, arbitration has become what is often referred to as the dispute resolution mechanism of choice in international commercial matters. You can see on the current slide, I apologize for the minuteness of the type, a chronological listing of the number of international commercial arbitrations conducted by only a selection of leading international arbitral institutions over the past 20 or 25 years or so. That number has gone pretty steadily upward. There's been a leveling off in recent years, but that's a leveling off only amongst the major international arbitral institutions. One phenomenon that has occurred quite significantly in the last 10 years in particular has been the growth of regional arbitral institutions in, for example, Milan or Dubai or Kuala Lumpur. Arbitration institutions that historically had very limited caseloads and which now are seeing an expanded growth. When you put those numbers together with these numbers, when you take investor-state arbitrations and ad hoc arbitrations into account, I think what one sees is a very steady and progressive increase in the number of international arbitrations. Why is it exactly from a lawyer's perspective? This is at the Magna Charta Institute, which studies law, and therefore why from a lawyer's perspective? What is the legal framework that gives effect to international commercial arbitration agreements? You can see the structure of that framework on the current slide. At the top, there are international arbitration conventions, which are almost uniquely successful as compared to other private law international treaties. And we're going to look at several of those conventions, in particular the New York Convention, in just a moment. There's international arbitration legislation adopted in individual states. We're going to look at that. Beneath that, we're going to look at the arbitral seat and its importance both under the international arbitration conventions and national arbitration legislation. We're going to look briefly at arbitration institutions, and their procedural rules, how those procedural rules play an important role in structuring and creating the legal framework for international commercial arbitration. And finally, we're going to look at best practices, it's sometimes called soft law provisions regarding the conduct of international arbitrations, in particular some soft law issued by the International Bar Association. Starting point, though, for our exploration of the legal framework for international arbitration are the three main international arbitration conventions or treaties. The most important of these by far is the so-called New York Convention, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, more specifically, more precisely. Signed, as I mentioned previously, in 1958, 149 states are now party to it. It has rightly been called the most successful private international law treaty in history. It has been remarkably successful indeed in encouraging the use and facilitating the enforcement of international arbitration agreements. Also important, though, are the Inter-American Convention on International Commercial Arbitration, also referred to as the Panama Convention, and the European Convention of the same name. The next slide, looking here at the New York Convention, as I've mentioned, the most successful private law treaty in history, I think it is safe to say. It has two main effects. Firstly, it mandatorily requires all 149 contracting states to recognize and enforce international arbitration agreements, subject only to very specific, limited, and exclusive list of exceptions. basic principle: international arbitration agreements shall be enforced and recognized. The second main effect of the New York Convention is to do precisely the same thing for international arbitral awards. That means to mandatorily require 149 contracting states to recognize and enforce international arbitral awards, subject only to very limited exceptions. The first of those two effects of the Convention you can see in the current slide, and this is effectuated in Article 2, and in particular Articles 2.1, subparagraph 1, and Article 2, subparagraph 2. The fundamental requirement for the presumptive validity of international commercial arbitration agreements is stated in Article 2.1. You can see it on the slide. Each contracting state shall recognize, mandatory, shall recognize an agreement in writing under which the parties undertake to submit to arbitration all or any of the differences which have arisen or which may arise. We saw that before, right? Past disputes, a submission agreement, future disputes which may arise between them in respect of a defined legal relationship, whether contractual or not, concerning a subject matter capable of settlement by arbitration. Basic obligation: every contracting state shall recognize agreements to arbitrate. And then in Article 2.3, referred to just in passing at the bottom of the slide, a remedy for Article 2.1, a requirement of specific performance. If the parties have entered into a valid arbitration agreement, national courts are required to, quote, refer them to arbitration, send the parties to arbitration, and importantly, not hear the dispute themselves. Precisely the same thing is accomplished by Article 5 and Article 3 of the New York Convention, which you can see on the current slide. Article 3 mandatorily requires contracting states to recognize foreign arbitral awards. Article 5 has a very limited set of exceptions to that obligation, exceptions only for excesses of jurisdiction, violations of fundamental procedural rights in a serious way, public policy, a very limited set of exceptions which only rarely result in non-recognition of arbitral awards. Note that the Convention, the New York Convention, addresses the recognition of foreign arbitral awards, and we're going to look in a moment at the concept of the arbitral seat. The New York Convention does not address a contracting state's authority to annul or vacate or set aside an arbitral award made in its own territory. Considered concretely, what the New York Convention does in Articles 3 and 5 is to provide that if an award is made in Switzerland, then 148 other contracting parties to the Convention, Germany, Austria, Italy, France, United States, Japan, Korea, Singapore, all must recognize that award, that foreign award made somewhere other than those particular jurisdictions, made in Switzerland, must recognize that award in accordance with the terms of the Convention. What the Convention doesn't directly do, is affect the authority of Swiss courts to annul an award made in Switzerland. That award is in Switzerland not a foreign award, which is what it is that the Convention regulates. It is rather a domestic award, and the Convention, therefore, does not directly address or directly restrict the ability, the authority of Swiss courts to annul, to set aside awards made in Switzerland. Just very briefly, the Inter-American Convention, also called the Panama Convention, 1975, 19 Latin American, North American states, does essentially the same thing as the New York Convention. European Convention, mostly European parties, more limited scope than either the New York or the Panama Conventions. Let's move on to consider the next layer in the legal framework for international commercial arbitration. Underneath the New York Convention, because that really is the global convention that drives the legal framework for international arbitration, or in those 149 contracting states, national arbitration statutes that implement the convention and, in some sense, elaborate on it, particularize its obligations. For the most part, national arbitration legislation is quite supportive of provides a pro-enforcement framework for international commercial arbitration, both agreements and awards, and the arbitral process itself. A very important instrument, you can see it referred to on the current slide, UNCITRAL Model Law on International Commercial Arbitration. Promulgated first in 1985 by the United Nations Commission on International Trade Law, UNCITRAL, revised not very extensively in 2006, but the model law, adopted in some 60 countries, we're going to look at its provisions in a moment, is fundamentally important, becoming increasingly important in today's world to the enforceability of international arbitration agreements and awards. Other national legislation, just as examples before you, there's here in the Netherlands the Code of Civil Procedure, which also addresses issues of arbitration, but almost every state that is a party to the New York Convention has a statutory framework for the recognition and enforcement of arbitration agreements, for the conduct of arbitral proceedings. The model law you can see here, adopted by more than 60 countries and a good deal more jurisdictions, provinces in Canada and states in Australia and the United States, takes that number a good deal higher. Among other things, Canada, Germany, Japan, Singapore, Hong Kong are examples of jurisdictions which have adopted the model law. What the model law does is provides a comprehensive legal framework, legislative treatment of the international arbitral process. And you can see some of the things that the model law addresses on the current slide. The model law expands and makes much more particularized the legal framework that we saw in the New York Convention. Among other things, the New York Convention in Articles 7, 8, and 9 contains provisions on the validity and enforcement of international commercial arbitration agreements. It contains provisions on what's called the competence, the jurisdiction to decide jurisdictional issues of the arbitrators. What that means in practice is if one party decides that it no longer wishes to arbitrate and seeks to challenge the validity or scope or existence of the arbitration agreement, the arbitral tribunal itself has the authority, usually subject to subsequent judicial review of some sort, to decide those jurisdictional issues, to consider those jurisdictional challenges, and to make a decision on them. Again, as I say, often subject to some sort of judicial review. The model law in Article 5 also contains a principle of judicial non-interference in the arbitral proceedings, a principle that it's for the arbitrators to conduct the arbitral process, not for judges to intervene. There's a provision also, you can see it in Article 1, 2, and 20, for the choice of the arbitral seat, provisions on the choice and appointment and challenge of arbitrators, Articles 10 through 15, provisions on provisional relief to freeze the status quo so the arbitral process can go forward, provisions on the conduct of arbitral proceedings, general procedural rules giving effect to the parties' procedural autonomy, requiring basic notions of fairness to be respected, and also specific provisions about submission of written pleadings and the like. A provision on the applicable substantive law, what contract law, what delict law applies by the arbitrators in the arbitral proceedings. Provisions on arbitral awards, their form, their content, when they can be issued. Provisions on annulment, very important, setting aside or annulling of awards. A court may review, but only in very limited circumstances under the model law, an arbitral award. Like the New York Convention, an award may be set aside, or analogously to the New York Convention, an award may be set aside in its arbitral seat, only on grounds of jurisdiction, excessive jurisdiction, gross procedural mistakes, public policy, very limited matters of that sort. A few countries permit a somewhat broader review of the merits of the arbitrator's decision, but most countries do not permit that, and even in those countries where it is authorized, for the most part, that review is very limited. The arbitral award is, for the most part, final and binding. And then finally, the model law, like other national arbitration legislation, also has provisions on the recognition and enforcement of foreign arbitral awards made in other jurisdictions. Now, very briefly, most national arbitration legislation provides a mechanism for the enforcement of international arbitration agreements. As I hinted previously, parties sometimes reconsider after a dispute has arisen their commitment to the arbitral process. They decide they'd really rather have the dispute resolved in their own home courts or somewhere else, not in a neutral, expert, efficient arbitral process, and they therefore challenge the validity, the existence, or the scope of the arbitration agreement. Different national laws provide different mechanisms for resolving those challenges. Almost all national laws, and the New York Convention, at least impliedly, recognize the concept of competence. In the first instance, the arbitrators have the authority to consider the jurisdictional challenge. Many national court systems also allow national courts to consider those challenges, sometimes at the same time as arbitral tribunals, sometimes only afterwards. Different countries, different national legal systems take different approaches to that question. But in almost all instances, even if the arbitrators go first, exercising their competence, there will be a measure of judicial review, often at the end of the arbitral process, as to whether they correctly concluded that there really was a valid arbitration agreement, taking us back to the foundational principle we saw at the beginning of this talk: arbitration, international arbitration, is consensual. We can just very briefly look at the next slide. We've seen this before. Article 2.3 of the New York Convention, parallel provision in Article 8 of the Model Law, providing for the recognition and enforcement of arbitration agreements. Number of specific issues that frequently arise in connection with arbitration agreements. Questions of formal validity. Does the agreement need to be in writing? Questions of substantive validity. Was the arbitration agreement impossible to perform? Was it procured by fraud? Was it unconscionable in some sense? Issues of so-called non-arbitrability. Certain subjects are not capable, under some national laws, of settlement by arbitration. Issues of criminal law, for example. The separability presumption. The arbitration agreement is, under most national laws, and also the New York Convention, I should say, separable, presumptively separate and autonomous from the underlying commercial contract, a principle that makes arbitration agreements much more durable, much more enforceable. Now, moving on just briefly, fundamentally important to the arbitral process is, and in particular for international commercial arbitration, is the significance of the arbitral seat. The arbitral seat, the place where the arbitration has its legal home or juridical domicile, is fundamentally important because of the consequences of the choice of the arbitral seat. The arbitral seat, and you can see this in the second and third bullet points, is the exclusive forum for annulment or set-aside actions with regard to the arbitral award, and the exclusive forum for the selection, appointment, challenge, and removal of arbitrators. What that means is if the arbitration is seated in The Hague, then it is Dutch courts and only Dutch courts that can annul the award, can set the award aside. It is Dutch courts and only Dutch courts that can appoint arbitrators, assuming you haven't selected an arbitral institution to do so, and remove arbitrators. Courts in Germany can't do either of those things. Courts in Germany cannot annul a Dutch award. Courts in Germany cannot appoint or remove an arbitrator in an arbitration seated in the Netherlands. This arises both from the basic constitutional structure of the New York Convention and also from the territorial scope of most national arbitration legislation. There are a number of other vitally important consequences that flow from the concept and choice of the arbitral seat. Among other things, and you can see these various items listed in the current slide, they prescribe, the laws of the arbitral seat prescribe the procedural standards for the conduct of the arbitration, standards of independence and impartiality for the arbitrators, principle of judicial non-interference in the arbitration. Courts in the arbitral seat, although they have some supervisory authority, in particular with regard to the arbitral award, can't intrude into, interfere in, micromanage the day-to-day conduct of the arbitration. There are also some practical implications of choice of the arbitral seat, which are not really hard law, the way the previous points that I made are, but are instead a kind of soft, indirect effect, but still a very important one. For example, the choice of the arbitral seat may very well have an important impact on who the presiding arbitrator is, or the sole arbitrator, what the procedures are likely to be in the arbitration. What seats are used in practice by commercial parties? You can see commonly selected seats on the current slide. They're in no particular order. Number of important European seats here in the Netherlands, Amsterdam, Rotterdam, The Hague. Elsewhere, London and England, New York and Washington, D.C. in the United States, Paris, Geneva, Zurich, and in Asia, Singapore and Hong Kong, all very frequently used. There is a fundamental difference that I'll only touch on briefly between, on the one hand, institutional arbitration, and on the other hand, ad hoc arbitration. Institutional arbitration is conducted pursuant to the rules of an arbitral institution, something like the Netherlands Arbitration Institute or the International Chamber of Commerce located in Paris, France. These institutions specialize in conducting international arbitrations. These institutions are not the arbitrators. They are an institution that helps select the arbitrators. These institutions don't decide arbitrations or make arbitral awards. The arbitrators do that. What the institutions do is help select the arbitrators and help conduct the administrative, the logistical, the practical aspects of the arbitral process, such as setting the arbitrator's compensation, such as ensuring that the parties' legal submissions are properly sent to the right places. Institutional arbitrations are usually, virtually always, conducted pursuant to a set of procedural rules promulgated by the individual institution. The ICC promulgates the ICC rules of arbitration, and administered by an expert court or secretariat responsible for applying those rules in particular cases. And the most important things that an institution does are select the arbitrators, hear challenges to arbitrators, fix the arbitrator's compensation, review the arbitral award for possible formal defects, remove arbitrators if they behave improperly or violate their standards of impartiality and independence. In contrast, ad hoc arbitration is conducted without the benefit of procedural rules, institutional rules, and conducted with only a national court fulfilling all the functions that the expert arbitral institution fulfills. Many commercial parties prefer the specialized expertise and non-governmental character of arbitral institutions in contrast to national courts, who often aren't as experienced in the process. Number of leading international arbitral institutions. Almost every major jurisdiction has at least one. You can see a list on the current slide. All of the institutions on this list have substantial experience in conducting international arbitrations. You have to exercise some care in selecting an arbitral institution in a particular case. There are differences between the institutions, which I can't touch on in the course of this lecture, but which make some appropriate for particular cases, but not appropriate for other cases. What is it that institutional rules do? They address a number of procedural aspects of the arbitration. How you start the arbitration, what your request for arbitration has to include, how you deal with jurisdictional challenges, questions of written and evidentiary submissions, challenges to arbitrators, and the like. The most important things that institutions do pursuant to their institutional rules is to appoint arbitrators if the parties can't agree, and to hear challenges to arbitrators if issues come up in the course of the case. In addition to institutional rules, I mentioned best practices, and this basically completes our four-part hierarchy: international conventions, national arbitration legislation, institutional arbitration rules, and finally, soft law. A number of different soft law instruments, you can see them on the current slide, deal with such things as conflicts of interest in arbitrators, taking of evidence, disclosure, witness statements in arbitration, guidelines on party representation, the conduct, the ethical guidelines, rules for counsel in international arbitrations. One can spend an entire session talking about the drafting of international arbitration agreements, the principal points that need to be included in an arbitration agreement. You can see on the current slide, you need an agreement to arbitrate, define the scope of what it is you're arbitrating. Do you use an arbitral institution or not? Where's the seat or the place of the arbitration? How do you appoint the arbitrators? How many are there? Language of the arbitration, choice of law provision, and then a number of other provisions that can optionally be concluded. What does a model arbitration agreement look like? This arbitration agreement is an example. It is drafted as an institutional arbitration clause, although I haven't specified the institution. You can look at the language on the slide. It's familiar from one that we've previously seen. All disputes, claims, controversies, and disagreements relating to or arising out of this agreement or the subject matter of this agreement shall be finally resolved by arbitration. There's an agreement to arbitrate as well as the scope of the arbitration agreement. Agreement to arbitrate is simple. All disputes shall be finally resolved by arbitration. Under the rules not specified, one could put in ICC or Netherlands Arbitration Institute rule by 3 arbitrators, 1 arbitrator, a choice to be made by the parties. The seat of the arbitration shall be Paris or somewhere else. The language shall be English. And that is an arbitration agreement, which is the foundation for the arbitral process. Out of that agreement comes the parties' consent to both go to arbitration and hence not go to national courts, and also to be bound, to be finally bound, subject to the enforcement regime of the New York Convention and National Arbitration Law by the arbitrator's ultimate arbitral award. What is this process, this arbitral process? What does it look like in practice? There is no generally applicable procedural code. It's not like in the Netherlands, where there is a code of civil procedure that defines the procedural conduct of a Dutch litigation, nor like a litigation in United States courts where the federal rules of civil procedure define every step of the arbitral process, of the litigation process. There's no generally applicable set of procedural rules that applies to all arbitrations. Instead, there are individual procedures tailored to particular cases. If you choose institutional arbitration, you have a skeletal set of institutional rules that define the high points, the outline, the summary of the arbitral process, but that don't fill in the details. That is instead left to the arbitral tribunal and to the parties. If the parties agree on particular procedures, they have procedural autonomy, given effect by Article 18 of the UNCITRAL Model Law and parallel provisions in other national arbitration legislation. If the parties don't agree, though, the arbitral tribunal has broad, very broad procedural discretion to devise procedural rules tailored to the parties' particular circumstances, subject only to a general requirement to treat the parties equally, fairly, and give them an opportunity to be heard. As long as the arbitrators do that, their procedural decisions will not be disturbed and their award will be given effect, or at least not set aside on procedural grounds. Importantly, arbitration is not litigation. Arbitration is different, for the most part, from national court litigation. Arbitration is intended to be less formal, intended to be more efficient, more practical, more aimed at getting to the substance, the commercial substance of the parties' dispute. It's usually like that. It's not always like that. Depends on what the parties want. The parties may agree to an arbitration that looks like, a lot like, a national court litigation, and if that's what they agree, that agreement, in recognition of their procedural autonomy, will be given effect. Very important principle, that of judicial non-interference in the arbitral process. Courts will not intervene. They will not say, the tribunal has scheduled a hearing for 3 days and it should be 5 days. The tribunal has provided for no disclosure, and we think there should be disclosure. The tribunal has said the language of the arbitration should be German. We think it ought to be Dutch. The national courts in virtually all jurisdictions will not micromanage the arbitration. Indeed, will have no involvement after selecting the arbitrators, enforcing the arbitration agreement if that's required, until the end of the process, reviewing the arbitral award. Principle of judicial non-interference. In this regard, the choice of the arbitral seat is extremely important because it defines what country's principle of judicial non-interference will apply, and just exactly what the relationship between national courts and the arbitral process will be. It will also define the arbitrator's the arbitrator's obligations of independence and impartiality. You can see examples of such obligations on the current slide. In principle, the arbitrators are required to be independent and impartial of the parties. That means all the arbitrators. That means party-nominated arbitrators, so-called co-arbitrators, sole arbitrators, and the presiding arbitrator. They're all required to be independent and impartial. The UNCITRAL Model Law, most national arbitration legislation, also provides a challenge mechanism by which this obligation is enforced. If an arbitrator violates her or his obligations of impartiality, there can be a challenge and a removal either by the arbitral institution, if it's an institutional arbitration, or a national court, if it is an ad hoc arbitration. Number of different institutional procedural mechanisms, different ways of dealing with challenges. For the most part, though, the aim is for them to be expeditious and not to delay the arbitral process. The IBA guidelines, soft law on conflicts of interest, fleshes out, in some commentators' views, not very helpfully, the details of what conflicts of interest need to be disclosed by arbitrators to the parties and what can provide bases for challenging and removing arbitrators. Parties' procedural autonomy, I've referred to previously, extremely important in the arbitral process. One of the basic reasons that parties agree to arbitrate, one of the fundamental cornerstones of the arbitral process. In the absence of agreement, though, by the parties, and parties don't always agree, indeed frequently don't agree on all the procedural aspects of the arbitration, the arbitrators have discretion to adopt the procedures of the arbitration to the particular circumstances of the arbitration before them. Arbitrators will, of course, be influenced by their background. Are they common law? Are they civil law? Do they have an Islamic or an Asian background? All those sorts of considerations, as well as the particular circumstances of the case, will affect very significantly the procedures you get in particular cases. We're coming close to the conclusion of the webinar, and if there are questions, by all means, don't hesitate to put them in to me online. We've looked now in some relatively fast detail at the legal framework for international commercial arbitration. Just a word on investor-state arbitration, and then just a final word on state-to-state arbitration, because I promised them to you at the outset of our program. Investor-state arbitration, a specialized type of international arbitration between investors, foreign investors who make what's called an investment in a host country. A German investor, for example, builds a factory in Pakistan. There are in force today between states from every part of the world, from every state of development, some 2,600 bilateral investment treaties, so-called BITs, which provide two things. One, a set of substantive investment protections, guarantees against expropriation, against denials of fair and equitable treatment. And secondly, procedural mechanisms for enforcing those protections. Those procedural mechanisms are in particular a right on the part of the foreign investor to take the host state to international arbitration if the host state violates its substantive commitments. There have been some 500 investor-state arbitrations over the past 25 years or so. The number has been increasing in recent years, and although the topic is one of some controversy and delicacy, there have been a number of important BIT awards involving, in some cases, quite substantial amounts of money. There are also multilateral investment treaties. The ICSID Convention, the convention for the creation of the International Settlement for the International Center for the Settlement of Investment Disputes, the ICSID Convention, very important. Also in North America, Canada, Mexico, the United States, the North American Free Trade Agreement, the Energy Charter Treaty, more in this part of the world, both provide for arbitration of selected types of investment disputes. Finally, state-to-state disputes, and just a word on this because these are rather exotic creatures, nonetheless interesting just to complete our our overview, our summary of international arbitration generally. This is not arbitration as we've seen between two private businesses, a German company and a Pakistani company. It's also not investment arbitration, a disagreement between a private company and a host state. It is rather arbitration with sovereign states, governments on both sides of the dispute. Arbitration is frequently preferred by states for many of the same reasons that commercial arbitration is preferred by businesses. More expert, more subject to the parties' procedural and other autonomy, more likely to be recognized, more likely to be subject to rules of confidentiality if that's what the states wish to agree. Here in the Netherlands, very important, the Permanent Court of Arbitration in The Hague, established pursuant to the Hague Convention of 1899 and subsequently amended, has administered a number of very important state-to-state arbitrations. The Eritrea-Yemen arbitration over the Zuckerhanish Islands at the end of the last century was conducted under the auspices of the PCA. The Sudan SPLMA arbitration was conducted just recently under the PCA administrative authority, and a number of other examples you can see on the current slide. Also ad hoc arbitrations, you can see examples on the slide as well. And states, just like private businesses, have found the possibility of resolving their disputes through a process that they have chosen, rules that they have chosen to govern their proceedings, with arbitrators who they have chosen to resolve their dispute as the most effective, the most durable, the most fair, the most expert means of resolving those disputes. States, just like private parties, don't want disputes. Disputes are a bad thing, not a good thing. Resolving disputes is difficult and frustrating, but the least bad way, both companies and states, whether in their capacity as a host state or as a co-equal with other sovereign states, have found arbitration over the decades, especially recent decades, to be the least bad way of resolving their disputes. And I hope that was helpful, if not too rushed, as an introduction to international arbitration. And that ends this Magna Carta newsroom. You can see the newsroom, and I'll have to read this out online, at www.avdr.nl under Law TV. And thank you very much for your time today.